All rise. Court is now in session. The Honorable Susan Ilston presiding.
Good morning. Morning. You may all be seated.
Now calling civil matter 25-CV-8302, American Federation of Government Employees, AFL CIO et al. Versus United States Office of Management and Budget. Counsel, please approach the podiums and state your appearances on the record.
Good morning, Your Honor. Danielle Leonard from Altshuler-Burzon for the plaintiffs. With me at counsel table are BJ Chisholm, Stacy Layton, Alice Wang, and Talia Stender from Altshuler-Burzon. And I'd like to introduce our co-counsel from Democracy Forward, Jenny Needler. Good morning.
Good morning, Your Honor. Elizabeth Hedges from the Department of Justice on behalf of the United States.
Good morning. Well, for the defendants.
Yes, sir.
Yes. Well, good morning to you all. First, let me say, at least to some of you, that I appreciate your being here and sharing your thoughts with me, because I know you're not being paid for your time, and it's a shame that that is the case. But I know from having worked with many of the lawyers in this room before that you are dedicated public servants and will do your jobs, and we appreciate that very much. And I'm sorry for the situation in which we find ourselves with respect to the payment. Today, we are addressing the plaintiff's request for a temporary restraining order to prevent any further RIFs being implemented during the government shutdown. I have a couple of things to say about the evidence that's been presented and my views on it, and then I'll be happy to hear from counsel to add to tell me what you want to tell me. I am inclined to grant the government's motion, the plaintiff's motion. The evidence suggests that the Office of Management and Budget, OMB, and the Office of Personnel Management, OPM, have taken advantage of the lapse in government spending and government functioning to assume that all bets are off, that the laws don't apply to them anymore, and that they can impose the structures that they like on a government situation that they don't like. And I believe that the plaintiffs will demonstrate ultimately that what's being done here is both illegal and is in excess of authority and is arbitrary and capricious. And unless I hear something that changes my mind, I would intend to enjoin what's going on. We talk about RIFs, and that's what the motion today concerns, but the RIFs are, of course, just firing people for reasons unrelated to their job performance, firing people unrelated to how well they are doing what they were hired to do, and firing them just because, in the view of the employer, it can. So that's what the RIFs are, is just mass firings. And what's happening here, and the evidence is substantial now that has been provided. I'll give you some examples. Some employees haven't even gotten their RIF notices because the notice goes to their work emails. They've been forbidden to go to their work emails while on furlough. This is the Department of Education I'm talking about. So they are not even in a position to get RIF notices when they're sent. Or if their email passwords expire, they can't get IT to help fix the email passwords because the IT staff are furloughed. This was at Department of Housing and Urban Development. Human resources staff have been furloughed or are themselves being RIFed, sometimes by human resources staff themselves. And employees can't navigate the RIF process, which is the firing process, without help from HR. There have been declarations filed concerning pregnant employees who are about to give birth and are worried about their health insurance lapsing, but they can't find out any information about that because HR has been shut down. There have been many errors made. I keep getting revised declarations under oath from people who say, well, I didn't mean the last one. I was off by about 2,000 because it's a fluid situation. And what it is a situation where things are being done before they're being thought through. It's very much ready, fire, aim on most of these programs. And it has a human cost, which is really why we're here today. It's a human cost that cannot be tolerated. By all appearances, and the appearances are created by the statements that are made by the folks in charge of the government these days, by all appearances, they're politically motivated. There are two primary memos that we're looking at in this case. One is the September 24th memo from OMB. It explicitly blames Democrats for the shutdown in the government. It says, congressional Democrats intend to shut down the government in the coming days over a series of insane demands. That's the memo from our government about the situation. On September 30, the day before the shutdown, President Trump was quoted as having said, well, we may do a lot, and that's only because of the Democrats. On the day after the shutdown, President Trump is posted on social media, I have a meeting today with Russ Vought, he of Project 2025 fame, to determine which of the many Democrat agencies, most of which are a political scam, he recommends to be cut, and whether or not those cuts will be temporary or permanent. I can't believe the radical left Democrats gave me this unprecedented opportunity. In addition, there was a video posted on President Trump's Truth Social called The Reaper, in which Russ Vought, he of Project 2025 fame, is portrayed as a reaper. On October 10th, the president said, speaking of RIF notices, which again are firing notices, it will be Democrat oriented because we figure, they started this thing, so they should be Democrat oriented. It'll be a lot. And we'll announce the numbers over the next couple of days, but it'll be a lot of people, all because of Democrats. So the politics that infuses what's going on is being trumpeted out loud in this case. And there are laws which govern how we can do the things that we do, and including laws that govern how we do RIFs. And the activities being undertaken here are contrary to the laws. The OMB memorandum, which is September 24th, they call it the lapse memorandum, says With respect to those federal programs whose funding would lapse and which are otherwise unfunded, such programs are no longer statutorily required to be carried out. As far as I can tell, that is completely untrue. It is not the law. It is inconsistent with the law. And if the OMB activities are premised on that, then that would go a long way to explain why they feel that they can impose these RIFs without complying with the law. They're overturning the agency mandates that Congress has put in place. They can't do that. October 10th, the LA Times published an article quoting OMB Director Russell Vogt, describing his long-term goals to bend or break the bureaucracy to the presidential will and deconstruct the administrative state. We want to make sure that the bureaucracy can't reconstitute itself later in future administrations. We are having fun. You can't do that in a nation of laws, and we have laws here, and the things that are being articulated here are not within the law, and in my view, exceed it, bend it, break it, and need to be enjoined. There's errors that are being made repeatedly in what's being done. I don't know if we have a new Mr. Billy declaration today, but we had a new one yesterday, and we had some from before, correcting errors that were made in prior ones. And I therefore feel that it is very likely that the plaintiffs are going to succeed in this case. And that's where I'm starting. And I will be happy to hear from counsel, but perhaps you'd like to go first. Ms. Hedges.
Thank you.
You're welcome.
Your Honor, before this court even gets to the merits, it can reject this lawsuit and this TRO motion because the plaintiffs haven't shown irreparable harm.
Yeah, let's just say I get to the merits, though. I think it would be more productive for you to address the merits.
Your Honor, we rest on our briefing insofar as the merits are concerned. We chose to focus on several threshold arguments that we believe are slam dunk arguments. And so at this preliminary posture, focusing on those arguments instead of getting to the merits.
So you're not going to get to the merits with me today because the merits are just so troublesome.
Your Honor, not today. I would note, of course, as Your Honor is aware, that the OMB lapse email in the record does have OMB's justification, and we would reserve the right to brief the merits at a later date. But in this truncated preliminary posture, we have several reasons why the court doesn't need to get to the merits of the motion, and that's what we've chosen to focus on.
Let me ask you this question. Do you think this is true with respect to these federal programs whose funding would lapse and which are otherwise unfunded? Such programs are no longer statutorily required to be carried out. Do you believe that's true?
Your Honor, so again, and I don't want to beat a dead horse, but we did not prepare to address that in this posture today. And so,
well, because you didn't prepare to doesn't mean you don't have to, because this is a hearing on the merits of this case, on the preliminary injunction, on the temporary restraining order. So you've chosen not to talk about it, but I'm asking you to talk about it.
right, Your Honor. And so I just want to, with respect, I don't want to evade the question at all. I just want to make clear at this posture, we don't have a merits position. We have a jurisdictional position. We have an irreparable harm position. We have ripeness arguments that do go to the likelihood of success prong of the TRO motion. But I don't have, we didn't brief it, and I'm not prepared to discuss the underlying merits of the.
So you don't have a position on whether it's okay that they do what they're doing?
In this posture, I'm not prepared to discuss that today, Your Honor.
Well, but it's happening. This hatchet is falling on the heads of employees all across the nation, and you're not even prepared to address whether that's legal?
Your Honor.
No, that's what this motion challenges?
So, Your Honor, that's right, because if any of our threshold arguments has merit, then the court wouldn't even get to those arguments for reasons that are discussed in some of the recent appellate court decisions that have been issued regarding channeling, regarding irreparable harm, regarding causes of action.
Channeling, for example, the last time I had a case, and I don't know if you were the lawyer for the defendants at that point or someone else was.
Someone else, Your Honor.
Okay, you got the short straw on this one, I think. The last time that got to the Supreme Court did not bite on your channeling argument.
If Your
Hard to say
Honor,
what they bit on, since they didn't really say too much, but they did decide that without agonizing over whether they had jurisdiction to do so.
that's right, Your Honor. What I would note about that, if Your Honor is referring to the previous AFG stay motion at the Supreme Court, the court did state that in addition to believing that the government would prevail on the merits, they found that the other stay factors were satisfied. And so I think that goes to irreparable harm, which is one of the arguments that we briefed in our opposition to the TRO motion here. So because of that, we do believe that that stay order supports our position here on matters like irreparable harm.
But not on channeling.
I acknowledge the court did not address channeling in its order, Your Honor. But the court did address, of course, as we've discussed, the merits briefly, and it then said that the other stay factors were satisfied. So it supports our arguments on the balance of harm in this case. So if I'm happy to talk about irreparable harm, we have several points why a TRO is not warranted in this posture. Most obviously, as we point out in our brief, a TRO lasts for a specific amount of time. It's very preliminary, and it would presumptively expire before any of the RIFs actually take effect. And as Your Honor has seen in the declaration that was submitted yesterday from Mr. Billy, the RIF notices that have gone out have a 60-day notice period. And in fact, the plaintiffs in their original motion acknowledged that any RIF notice would have a 30 to 60-day period under applicable regs. And so any harms that are related to the RIFs would necessarily occur months or weeks far out from now. And so that's kind of the most obvious reason. But even setting that aside, so let's assume that we get to that point, it's months or weeks from now, a RIF notice effective date has occurred. We're still dealing with classically reparable harms of the sort that the Supreme Court has said are reparable. Loss of employment, loss of benefits, loss of wages, those are the sorts of things that a body like the MSPB can remedy. Those are the sorts of things that a discharged employee in a civil lawsuit can potentially obtain a remedy for in district court. And so those are the sorts of harms that don't form the basis for preliminary emergency equitable relief. The other thing I would point out, the TRO motion talks about this notion of harms based on political discrimination. I don't need to say much more than what's in our brief. I would just point out that the plaintiffs have not brought a theory that would support that being a cause of action, much less that it would be an irreparable harm. So again, if the harm is...
You're not talking about the merits.
I'm not,
You're
Your
not
Honor.
talking about arbitrary and capricious and all the rules that apply to how a RIF needs to be administered. You're
Just-
talking about what now?
The irreparable harm theory that they tie to this alleged political discrimination, Your Honor. And I just wanted to briefly bring it up because I know Your Honor is thinking about it. So in the irreparable harm context, not the merits context, we explain in our brief why that is not an irreparable harm sufficient to warrant a TRO either. Because again, even if you were allegedly discharged for an improper purpose, that is the sort of thing that can be remedied before a body like the MSPB, or that could be remedied at the end of a lawsuit. It's classically irreparable harm. I think that's pretty much all I have to say on irreparable harm, other than what we say in our brief, which fleshes that out a little bit more. The other thing I would point out, and this is as to a subset of agencies. So as to the majority of agency defendants, which have not issued a RIF notice yet, there's an additional problem because they are still in the process of making a decision, and therefore we kind of have this even more protracted period between today's motion and any alleged harm that would occur in the future. So in addition to all the reasons I just addressed, which would apply to all of the agencies, for the majority of agencies which have not made a RIF decision yet, as discussed in the declarations we submitted, there's even more decision-making that still has to occur, and in many cases, there may never be a RIF at all. So the harms aren't ripe as to those agencies, and they also can't support irreparable harm. The other thing that we point out in our brief, and this is something that I don't think has come up before, Your Honor, before, but the plaintiffs don't have a cause of action under the Antideficiency Act, and this is...
Don't purport to.
Your Honor, they purport to proceed under the APA, but for the reasons we discuss in our brief, the APA is not a workaround if you have a detailed, comprehensive statutory scheme that has separate remedies like the Antideficiency Act does. So if you look at the Antideficiency Act, the remedies that are provided have to do with, there's criminal penalties, and there's also penalties like removal of the official that violated the provision. These are penalties that are dealt with separate and apart from a private lawsuit brought by an individual. And there are cases, including one from then Judge Ketanji Brown Jackson on DDC, that reiterate that there is no private right of action for declaratory, mandatory, or injunctive relief under the Antideficiency Act. And that's the Feldman case that we cite in our brief. So this is something that the courts have addressed. And then we, of course, we get to the APA piece, which is, can the plaintiffs work around the lack of a private right of action by going under the APA? And the answer is no, because under the APA, there's no cause of action if other statutes preclude judicial review. And so as discussed in the Anti-Deficiency Act, we have these unique provisions, but we also have the CSRA, the Civil Service Reform Act, and the Federal Service Labor Management Relations Statute, which both channel employment-related disputes to an agency adjudicator. And so that's a comprehensive way of resolving these sorts of RIF-related disputes that get channeled away from the district court. And that's another reason why proceeding under the APA in this posture is precluded. So I would just point your court to the cases that we cite in our briefing about that. The plaintiffs cite a couple of cases in their reply, but those cases, like the mock mining case, discuss a rebuttable presumption of judicial review, and they discuss very, very different statutory schemes like Title VII. And I would submit that to the extent there's a presumption, it's rebutted here for the reasons that I just mentioned. Your Honor is familiar with the channeling arguments, and I've already touched on them a bit. I would just point out that these arguments are in some more recent decisions, including the National Treasury Employees Union case out of the DC Circuit a couple of months ago. Those arguments are being adopted by appellate courts. And so, for example, in that National Treasury Employees Union case, which I believe came down exactly 2 months ago, the DC Circuit explains why the Civil Service Reform Act and these statutes channel claims away from district court. And the reason I bring that up is because that's a case that is relatively new. It's not the only one, but I think it just has a very cogent explanation of why these sorts of claims get channeled. And under cases like Elgin from the US Supreme Court, even constitutional claims get channeled. And judicial review isn't foreclosed because if you lose an agency like the MSPB, you can appeal to the federal circuit.
So you go to an agency that doesn't have jurisdiction to do what you want. They say, I can't do it, and you can appeal then. That's the idea?
I wouldn't say they don't have jurisdiction, Your Honor. I think it depends on the case and the type of claim. I think this type of claim is exactly the sort of thing that the MSP has jurisdiction to resolve. The claim that's being made is similar to that which was discussed in some of these Supreme Court cases, which is a statute is being violated. That's the allegation. I'm being discharged in violation of a statute. And that is exactly the sort of thing that entities like the MSPB are always adjudicating. But cases like Elgin recognize that, yes, even if you can't get the relief that you want at the MSPB, that doesn't mean that the claim wasn't channeled, because the question is the type of claim. It's not the type of argument you're making. So if your claim is a challenge to an employment action, that's the sort of thing that gets channeled. And then depending on what the nuances of the arguments are, the MSPB or the Federal Labor Relations Authority may or may not issue a reasoned ruling on that, but in any event, you have appeal rights from there. So, Your Honor, I don't want to belabor this too much because I know Your Honor is familiar, but we would submit that those arguments are still meritorious and they're being adopted by appellate courts. Just a few more things, Your Honor. I do want to reiterate, and I touched on this briefly, but I want to make sure I'm being clear. So we do have a separate ripeness argument as to the agencies that have not issued RIFs yet. And as Your Honor has seen in the declarations that we've submitted, as of today, that's the majority of the agency defendants have not made a final decision whether to issue a RIF. And so as to all of those agencies, we have a ripeness argument, which is that the RIFs may not occur as anticipated or at all. And this is page 15 of our brief where we discuss this standard. The other thing I'd point out is on the OMB lapse email, or lapse memorandum as it's been called. So as we point out in our brief, though that memorandum does not make any given RIF decision at an individual agency final, because the agencies, as we've seen, are making their own determinations of whether a RIF is appropriate. And so we are making a ripeness argument not as to the OMB lapse email itself, but as to RIF decisions at individual agencies that haven't made those decisions yet. And so I just want to draw that distinction because I think it's a distinction between this case and the previous AFG case that was before Your Honor and continues to be before Your Honor. And then for similar reasons, there's no final agency action under the APA as to those agencies that have not yet made a RIF decision. And Your Honor, I do want to address, Your Honor noted that there have been 2 declarations so far. So, sorry, 3. One from HHS that Your Honor saw yesterday, and 2 from OMB. And the second OMB one was submitted in response to Your Honor's Friday night order. And it updates some of the numbers. And I think what those updates show is both it does correct some things where the declarant previously either didn't have complete information or he received updated information. But in addition to that, it kind of underlines the point about the lack of agency action, because those agencies have been going through a decision-making process and they've been reporting out numbers so far, but as to all of the other agencies, it's still the case that there's no numbers to report because they haven't made a RIF decision. So to the extent that the situation on the ground is in flux, that supports the notion that the OMB lapse memorandum did not settle things for all time as far as individual agencies' decisions go. Individual agencies are still making those decisions, and many of them may well decide not to do RIFs at all, which is the status quo as to those agencies. Your Honor, I'm mostly going to rest on my briefs as to the equities. I do want to make a couple of points before I sit down about the scope of relief. So to the extent the court were to decide to enter relief, there are some things that we submit should be considered regarding the scope of relief. We do point out in our brief that relief should be justified by a showing by plaintiffs that they actually have members in any given component at which a RIF has occurred. So that would mean that relief should not be entered as to agencies at which RIFs have not been announced. And it would mean that relief should not be granted to agencies or agencies subcomponents where RIFs are not being carried out with respect to the plaintiff's members. And I'm happy to answer questions about that, but I think it's pretty clear in our brief. And Right. So I would just make the point that, again, standing is not dispensed in gross. Irreparable harm, there has to be a showing as to given plaintiffs. And so to the extent there hasn't been a showing that a RIF is actually occurring that would affect or that would apply to members of AFG at any given agency subcomponent, any relief should not extend to those agency subcomponents. So I think with that, Your Honor, I would just reiterate the points we make in our brief. We don't believe the court has jurisdiction over this matter for the CSRA and other channeling reasons that we mentioned in our brief. But in any event, we don't think that the plaintiffs have irreparable harm. And I would just stand on my briefs as to the remaining arguments unless the court has questions about them.
I just want to be clear, you're not making any statement concerning the government's position on the merits of this, on whether these RIFs are legal or not.
Not today, Your Honor.
Thank you.
Thank you.
Ms. Leonard?
Thank you, Your Honor. I'll be brief. But first, I want to add a few facts from our reply papers to the facts that Your Honor elaborated at the outset of this hearing, because I think they help illuminate what's actually happening, contrary to the information that counsel just discussed with respect to the final decision-making, and contrary to the declarations that they have submitted to this court. The decisions, Your Honor, have already been made. All the elements of implementation do not need to have occurred yet in order to enjoin those decisions. And how do we know this? Because OMB and the president relentlessly are telling us, and other members of the administration. In our reply papers, statements from just yesterday, OMB is making every preparation, OMB, not the agencies. OMB is making every preparation to batten down the hatches and ride out the Democrats and transigents, pay the troops, pay law enforcement, continue the RIFs. And wait, that's the Walls Declaration Exhibit B. The president, just yesterday, before defendants filed that supplemental declaration, we are closing up Democratic programs we disagree with, and they are never going to open again. More cuts are coming Friday. These are the actual facts. Your Honor talked about HHS and what happened. RIF, the employees, and then RIF HR. They had to RIF themselves. And then they put some of those employees back and did not put the HR people back. To go to harm, we've identified the harm that is happening now. In the past few days, we have scrambled to find evidence, to give Your Honor, to show exactly what happens when employees receive these RIF notices and when they receive them in the context that they are receiving them, which is the government shutdown, when they are furloughed, when their emails are cut off, when they've been told that they can't access their emails, as Your Honor pointed out. People don't even know about the RIFs. The harm is now. There are multiple types of harm that are caused exactly right now. Emotional trauma, that's not my word, Your Honor. That is the word of OMB Director Russell Vogt. Let's cause trauma to the federal workforce. And that's exactly what they are doing. Trauma, the emotional distress of being told you are being fired after an already exceptionally difficult year for federal employees. We all know what has happened to date, and now this on top of it, when they're not being paid, they're making people come in, work without pay to fire their fellow employees. And then those employees are being fired in this context. It is traumatic, it is distressing, it is preventing employees from clarifying mistakes, the host of mistakes that's already happened. If anyone believes that's just a coding error, what happened at HHS over this weekend, as opposed to a decision by OMB to fire people that include people who are actively working on measles outbreaks, Your Honor, that's who they fired. And someone realized what a poor decision that was. That's what happened. They can't fix errors. The list goes on. We've addressed all of this in the brief. counsel for the government, for the defendants, for all defendants, counsel stands here representing all defendants, did not address any of the harm that is happening now. They just say, losing your job is not a big deal, we can fix that later. Well, in other cases, this government has certainly argued that there is no remedy. But we don't need to go into that to address the fact that there is real harm now, and they don't even address it. They just say you can fix the harm later, and that in and of itself is not even true. Losing your health benefits, of course, is irreparable harm under Ninth Circuit law that they ignore, Your Honor. With respect to what counsel called, quote, slam dunk threshold legal arguments that they choose to address rather than facing the fact that the actions of the government are so completely unlawful, they can't even mount a defense on the merits. Were they to try, Your Honor, we'd be in Rule 11 territory on these issues. The slam dunk threshold arguments channeling, counsel has neglected to directly address binding published precedent from the Ninth Circuit that is directly on point, as Your Honor is aware. The AFGE v. Trump case decided by the Ninth Circuit on channeling is on all fours with this case. It's published precedent. So when we're talking about other decisions from the DC Circuit within the past few months that are somehow persuasive without talking about the case that is directly on point and is binding on this court, perhaps we've gone back in time. That decision was May 30th, 2025, Your Honor. It's binding precedent, as the court knows. It is remarkable that the government failed to even cite it in their brief and to address it here today. That is all I'm going to say about channeling, because the case is on all fours. It's binding. There's jurisdiction. We can move on. Implied preclusion, this argument that there's no right of action under the APA because there happen to be some remedies in the ADA. Well, you don't even need to get there because we have arbitrary and capricious claims under the APA that the government ignores. So those are not subject to that implied preclusion argument at all. But even if you did get there, the cases that they cite do not support the conclusion that there's any conflict so that you would preclude the command of judicial review in the APA by implication in that statute simply because it happens to apply to the same thing. That is not how the law works. We've addressed that in the brief. And again, that position by the government finds no support in the case law whatsoever. The case from the DC District Court that counsel referred to is cited for the fact that there's no private right of action under the ADA. We're not suing directly under the ADA. It's a completely different issue. Ripeness and final action. Again, counsel ignores the binding decision in AFGE v. Trump, in which the Ninth Circuit said, final agency action, you do not need to wait for all the elements of a decision to be implemented across agencies in order to sue, to enjoin, to address as unlawful the decision. The decision here has been made. It has been made at the highest levels of government. It's been made by OMB director vote to unlawfully order agencies across the federal government to RIF their employees. If they haven't decided yet exactly the timing, that matters not for our ability to challenge and enjoin this, Your Honor. But I believe that they have decided the timing. And this is very important because it goes to the scope of relief and counsel's arguments here. They can't hide behind the fact that they haven't revealed their actions to this court to argue that the court doesn't have the ability to address it. And that is exactly what the Department of Justice is doing here. They have failed to give the court the information that you asked for, that this court asked for, what RIFs are being planned. They have refused. I think they're invoking deliberative process privilege. We have been here before, Your Honor. Mr. Billy, those declarations are not even close to what they would need. But contrary to the statements there, the decision's already been made and we know it. We know it because the president OMB spokespeople for the administration being quoted on condition of anonymity in the press. They have all said, we're doing it. Vice President Vance on Meet the Press on Sunday, we're doing it. The decision's been made. It's just a question of implementation and timing. I believe they've already made the decision what agencies are going to RIF people on Friday because, Your Honor, those RIF notices don't happen in an instant. Someone has to prepare them. The work is being done by federal employees to prepare RIF notices at agencies, probably as we speak, without being paid in violation of the law. And they are refusing to tell the court where that has happened. They can't hide behind this and say the court shouldn't issue injunctive relief as to those other agencies on the false representation that they have not taken action and made decisions that we know for a fact they have. That is highly inappropriate, Your Honor. The fact that they haven't disclosed it doesn't mean that we can't seek that relief. Now, Section 705 of the APA gives this court all the authority it needs to stay the further implementation of the OMB memorandum and any decision that has been made, any unlawful decision that has been made. 705 gives this court, Congress gave this court very broad authority in the APA to enjoin any unlawful decision and stay it going forward. And that's all we've asked for right now. And counsel made the point about the scope of the injunction and the union members. And I had to shake my head in disbelief because they've refused to even disclose to this court, let alone publicly, where the already existing RIFs have occurred. They've given, Your Honor, estimates rather than actual numbers. Only one agency, HUD, did the union receive notice of who was going to be RIFed. And we know it's about 3/4 of the total number in the Billy Declaration that the union was notified of at HUD. Elsewhere, we have worked very hard, but we don't have the information that the government is hiding with respect to where their existing RIFs have already reached, let alone where they are planning and have already made the decisions and preparations to RIF. In that context, on this record, before this court should enjoin it all at those agencies, Your Honor. And we're happy to answer questions. We're happy to answer any questions about how to do that and how to implement that consistent with what we've asked the court to do in this case.
Well, that was and is one of my questions and concerns about the current motion is, practically speaking, we don't know very much about whether it's plaintiff union members or not being affected by the various actions that are described and then that are not described. So you think there is power or authority to enjoin it all?
I do, Your Honor. I think 705 gives you the authority to stay the unlawful actions temporarily while you set this for a PI, absolutely. And we all know that the scope of relief under the APA in general is to hold unlawful and set aside the entire thing. That vacature and all of its effects. So if the OMB decision, the OMB instruction, the OPM instruction to use people is unlawful, this court is going to have the authority at the end of the day to wipe that out in all of its effects. But as this first step, this court certainly has the authority to just hit the pause button on what is happening here, particularly in the context where they're issuing RIF notices, taking them back the next day, making a ton of mistakes. So how can we even, and not giving the court the information, not giving the court the accurate information about who is being affected. In that context, it's absolutely the case that Your Honor can say the defendant agencies where the plaintiff unions represent, that's who we've sued. We haven't sued every agency of the federal government. We've sued the agencies where the defendant unions represent people. And if they're not revealing, sorry.
The plaintiff unions?
Plaintiff unions, thank you, Your Honor. I misspoke, obviously. The plaintiff unions represent people. Those are the defendant agencies in this case. And that's the relief that we've asked for. And it's absolutely appropriate without further information from the government. Without further information from the government about what exactly it is that they're doing and they're planning and what was the president talking about? What is OMB talking about when they say continue the RIFs? Where? Without further information, this court absolutely has the ability to enjoin further RIFs at those agencies, Your Honor.
Thank you.
Maybe briefly.
Sure.
Just 4 very quick points, Your Honor. On irreparable harm, the case we cite in our briefs, Sampson from the U.S. Supreme Court, that's the case, one of the leading cases that says that harms such as loss of income, loss of benefits, employment-related harms, those are reparable harms. And not only the Sampson case, but we cite a case from the Ninth Circuit called Hartica that says similar things. And so I just want to be really clear, if actually losing employment is not an irreparable harm, then getting information that you are likely to lose your employment is also not irreparable harm. And we do respond to some of the other more other assertions in our briefs. There's also case law, and I believe Sampson says this as well, that merely expending resources such as the unions alleged to have done is not sufficient to support irreparable harm. So just to reiterate that we do address those allegedly immediate harms in our briefs. Secondly, on the Ninth Circuit's decision in the previous AFG litigation, we certainly did cite that in our brief, and I did address it here today. I'm happy to talk about the Ninth Circuit's decision in particular. As Your Honor is aware, the U.S. Supreme Court, as we discussed this morning, subsequently stayed the injunction. So setting aside, I'm not disputing that the Ninth Circuit said what it said in that decision, but the fact remains that the U.S. Supreme Court subsequently determined that the injunction should be stayed. And so that supports our argument that emergency equitable relief is not appropriate here. Third, with respect to the scope, there's one thing I forgot to say that I also want to make clear. If Your Honor looks at the second Billy declaration, and I believe the first one as well, which I know Your Honor has done, there are a few agencies that have not accepted employees to work on RIFs, and the exact language is in the declaration, but basically, I believe energy is an example. Employees have not been accepted as that term is being used in this context because those agencies are not currently experiencing a lapse of appropriations, as I understand it. And so what that means is that if Your Honor were fashioning a scope of relief, if Your Honor reached the merits of the Antideficiency Act issue, those agencies are not actually operating under a lapse. So they, as I understand plaintiff's allegations, wouldn't even be in that universe. So that's something that Your Honor has before Your Honor to address the scope of relief if Your Honor gets there. Finally, on the declaration, I just want to stand by the declarations that we submitted in this case. I understand that information is changing and that I think if we could have just submitted one declaration that was correct for all time, then our declarant perhaps could have done so, but that's not the situation we're in. We're in a situation where things are changing on the ground and some of these decisions have not been made, or new information comes in and things need to be updated, but I stand by the integrity of the declaration. And the last thing I'll say on that, just to respond to something that was said a moment ago by my friend, is that my understanding is that that declaration was responsive to the court's order. The court asked for information regarding which agencies intended to issue RIFs during or because of the lapse in appropriations. And so the information in the Billy declarations is tailored to that, and also the additional detail in the HHS declaration that we submitted yesterday. So we sought to be responsive to your Honor's order, but we will continue to seek to be responsive to your Honor's orders.
All right,
So
thank you.
with respect to the rest of the arguments, again, I would rest on my briefs, Your Honor, and we would ask the court to deny the TRO. Thank you.
Just one last chance. Any thoughts on the merits of these questions?
So again, Your Honor, to double back to something I just said, I think the most merits-ish issue that I'm prepared to discuss is that issue of some of these agencies haven't accepted employees. So even taking the plaintiff's arguments about the Antideficiency Act at face value, my understanding is that those agencies like Energy aren't even in that universe of having accepted employees under the Antideficiency Act to work on RIFs. So I think at a bare minimum, any relief would have to exclude those agencies because they're not even doing the thing that plaintiffs are alleging is a violation. So that's what I would say, Your Honor. That's a scope of relief issue that's not squarely on the merits, but that's what I would say about that.
When did you think, when does your client think it will address the merits of the case?
Your Honor, I think, so as of this point in time, as Your Honor is aware, this is a short-lived lawsuit. I think we would need to determine based on whatever happens next, what the next move would be. So I can't make a commitment.
It's lawsuit, but it's a lawsuit about something that's been in the works for quite some time. So I would think it would be possible for your colleagues to take a position on the merits reasonably promptly.
Your Honor, I can certainly discuss with my colleagues. I came prepared to discuss these other issues today, and so I'm not going to discuss them today, but we can certainly, depending on next steps in the litigation, we may be able to address the merits at the next stage. But
Okay, all right, thank you.
Thank you.
What about that last point on the energy and
Happily, Your Honor. Our arbitrary and capricious claim absolutely still applies to any RIFs that are being imposed and directed at the Energy Department on the grounds of, because the programs there are, as the president has said, Democrat-oriented, which is what's happening here. So even if they are correct, and we have not had the time to investigate this claim with respect to what is happening at Energy, in part because we don't actually know what parts of Energy are being affected by this, as counsel, we have some information about that via the press, as counsel has refused to tell the court. Even if it's true that there is separate funding for parts of Energy that's not affected by the lapse in discretionary funding, so therefore they are exempt as opposed to accepted. Even if that's true, the arbitrary and capricious claims, at least in part, would absolutely still apply.
all right, thank you. Okay, anything else for now?
No, Your Honor.
Okay. All right, well, I will issue something today in writing, but as of right now, I am going to order that the plaintiff's request for a temporary restraining order is granted. So as of right now, the TRO is in effect. The defendants, and as I say, it will be specifically articulated, but under 5 U.S.C. 705, it is ordered that the defendants are enjoined from and stayed from taking any action to issue any reduction in force notices to federal employees in any program, project, or activity that includes any bargaining unit or member represented by plaintiff during or because of the federal government shutdown, including, but not limited to, taking any action to implement or enforce the OMB lapse memorandum or the OPM guidance for shutdown furloughs. They're enjoined from taking any further action to administer or implement RIF notices already issued beginning on October 10th to federal employees in any program, project, or activity that includes a bargaining unit or member represented by plaintiff, including but not limited to requiring federal employees to perform work to further administer or implement RIF notices, and by enforcing or counting any days toward any period of notice with respect to those notices. It is further ordered that within 2 business days, defendants shall serve and file an accounting of all RIFs, actual or imminent, that are enjoined by this TRO, including but not limited to a description of the agency that imposed or is planning to impose the enjoined RIF, the number of employees included in the enjoined RIF, and description of the PPAs that defendants included in the enjoined RIF. And it would be really helpful if those declarations were provided by people with knowledge of what they're saying. It is further ordered that within 2 business days, each defendant shall file a declaration verifying that they have complied with this order and that the steps and verifying the steps they have taken to do so. Now, as I say, I'll get you a written order, but that is ordered as of now. When do you want to come back for a preliminary injunction? To request one?
Your Honor, I would prefer updating regarding on a PI hearing, but I can get back to you as soon as possible with that.
Okay. Is that today?
I think so, Your Honor. I think I can get back to you today.
Okay. Ms. Leonard?
So, Your Honor, 2 weeks from today, I believe, is October 29th. And so we would be prepared to have a preliminary injunction hearing at any time before the 29th.
Okay, well, I would request then that you stay in touch with Ms. Hedges. Ms. Hedges will get in touch with her office and then get me a date. And once I've got a date, then I can give you a schedule for briefing. It would be wonderful to know what the government's position is on the merits of this case. And my breath is bated until we find that. So that's what the briefing can say.
We would suggest the 28th for the hearing, Your Honor, if that's
that a-
open for the court.
Is that what day of the week is it?
I believe it's a Tuesday. It's today, Wednesday. It's a Tuesday, Your Honor. Losing track here.
Okay, well, that's okay with me. And so check, as I say, stay in touch nicely with one another on what those dates should be.
And we would request, as we set forth in our proposed order, the opportunity to brief the preliminary injunction motion.
Oh, yes, I will want that. And I will set a schedule for that, but it's going to have to work backward from the date you choose for the hearing.
And given that we'd go first, we'd request that the government provide confirmation of the date today.
Yeah.
Your Honor, I'll confer with my team as soon as I get out of courtroom, and we will confer with plaintiffs with that.
All right. Thank you. All right. Thank you. We're in recess.